There we go. All right. So once again, I'm Thomas Haag from Seyfarth Shaw, where I co-chair the Life Sciences and Chemical Patent team in DC. So I'll dispense with the introduction. We've gone through that, and the point of this talk, as the title of the workshop suggests, is developing robust IP strategies and sort of thinking beyond patents. While I'll be touching heavily on patents in my discussion, the aim of my talk is to focus more on a lot of the ancillary issues surrounding patents and IP in general, which may not be so apparent at first blush or not so frequently discussed. So the bottom line is, when you're creating a intellectual property strategy to manage a portfolio and create a robust portfolio and to fully leverage that portfolio, there's not going to be a one-size-fits-all strategy for any given set of circumstances. Rather, strategies need to be created in a very bespoke and thoughtful manner. And that requires a bit of introspection, figuring out who I am and where I want to go. What do I want to achieve with my business and my intellectual property? And then I've created 3 different scenarios in which I've created intellectual property strategies for each one, and I'm going to be talking about product and corporate development in the life sciences industry, using sort of the typical biotech, biopharma business model as a backdrop. So as I mentioned, came over from Fennelly Haag, which was acquired by Seyfarth, which is an international firm. And again, sort of skipping that introduction and hopping right into the talk. Obviously, creating and maintaining an intellectual property portfolio is a very expensive proposition, both in terms of time and money, technical resources. And how can we maximize this investment, this deep investment, is obviously the question on everybody's mind. The sort of typical method which one frequently sees, particularly in instances where patents, for example, are being filed in a manner to sort of minimize costs, so there's not a lot of upfront thought into what's going on with a particular patent portfolio, but a sort of a robotic approach of sort of preparing and filing and prosecuting patent applications with sort of no real alignment of those patents and patent families with particular business outcomes is a very inefficient strategy, as you can imagine, and obviously is somewhat of a financially self-defeating proposition. So we're here to talk about today about thinking about the portfolio more holistically, and thinking just beyond the typical patent issues of obviousness and subject matter eligibility, anticipation, written description type issues, but we're thinking more holistically in terms of how do I manage a portfolio of intellectual property in any given stage of a business's or product's development. And to the extent that you've been through, and I'm sure you have, due diligence investigations in the context of an intellectual property-based transaction, such as a license, an acquisition, an IPO, you'll probably recall that there are a number of legal sideshows, I call them, which pop up, which are the result of improperly having previously addressed or not addressed often foreseeable issues surrounding protectability of IP, freedom to operate, and chain of title issues. And these sideshows can be very costly, take a lot of time, and can delay deals and potentially derail them. And that's obviously what nobody wants, that particularly where the deal is mission critical for the company. So with respect to the drug development model and in the biopharma space, and presumably this translates to other industries as well, a real deep familiarity with the nuances and realities of a particular industry, in this case drug development, biopharma deal making and patent litigation, along with careful legal planning are really essential to creating intellectual property strategies that will yield high returns on the high initial investments. So starting off, as I mentioned, there's a bit of introspection that needs to take place as the first step in creating any intellectual property strategy. So, and primarily this is with respect to corporate development, and in other words, what stage of company am I in? What are my resources? What can I work with? And what's going to be important? What should I focus on? And that's going to be different whether you're a startup or a mid-sized private corporation, publicly traded mid-cap biotech or pharma company, or whether you're a well-capitalized multinational biopharmaceutical company. And then, of course, strategies are going to be linked to particular assets, either products in development or drug discovery platform technologies, for example. And so it's very important to consider at what stage is this technology in its development. Are we talking about a discovery stage, proof of concept stage? Are we moving towards preclinical studies, for example, toxicity studies? Or are we in one of the three phases of clinical development, phase 1 through 3? Or are we post clinical development and already in the market and doing post-marketing studies? So I've created a table here to sort of map out, on the one hand, across the top, the various stages of drug discovery and drug development. Again, discovery, proof of concept, phase 1 through 3. And then vertically listed the various stages of a typical biopharmaceutical company's corporate development, going from a very early stage friends and family seed round financing all the way through a Series A and B to an IPO, and whether you're a big pharma company. So if we sort of match up any given technology, assets, stage of product development, and compare and look to see and match that up with a particular stage of corporate development, we can see that there are roughly 3 different types of IP strategies that one should be pursuing at any given time. And I've just termed them early, mid, and late stage strategies. So the key factors driving the value of any intellectual property asset really relate to the chain of title to the technology and the scope of what's actually your technology, the patentability or protectability of that technology, the freedom to operate issues. Can you exercise and can you pursue and can you commercialize your technology without running afoul of third-party IP? And then other sources of exclusivity that can be leveraged. For example, regulatory approvals and other barriers to market entry, such as a competitor's time that it would have to invest to create a competitive product. And all of these factors, although all important, are all of varying priority with respect to the mid, early, and late stages of IP strategy, IP portfolio development strategy. And of course, with respect to these 3 different strategies, the point of each one is to minimize or defray costs and maximize protection. Those are the obvious aspects and goals. But an additional key goal is to really avoid foreclosing downstream options. So when you're pursuing your early stage strategies, you should be doing so with an eye to maximizing the amount of options available to you later on down the road, because there are different points at which biopharma companies are typically acquired, or different points at which they have strategic transactions, and the partners that they will be working with to take a technology forward are going to be perhaps pursuing a mid or late stage strategy, and they need to know that the early and mid stage strategies that have been pursued have not foreclosed any avenues and options for them as they're pursuing their late-stage strategies. So hopping right into an early-stage strategy, at this stage, we're talking about a startup company potentially spun out of a research institution or a university. And the key at this early stage really is you're not thinking about, you're not necessarily sure what the exact product is going to be. You're not so much worried about enforcing a patent against a competitor. You're thinking more about how can I define what it is my technology is, how can I ensure a smooth transition of that technology and transfer of that technology from the university or academic context or research context into a more of a commercialization mode. And this really involves translating the technology into the currency of intellectual property. And what that means is thinking about the technology and defining it and memorializing it in a way in which investors and downstream actors can understand. And that generally involves drafting patent applications. So drafting patent applications and putting down and describing the technology in a manner that gives you the most options to broadly claim the technology down the road. And only when this sort of process is completed will investors and partners feel comfortable putting their money into the technology and taking it forward. And time again, I've seen in due diligence investigations and in transactions that chain of title issues here are critical. And so in order to best prepare for due diligence at this stage, companies shouldn't necessarily be thinking a whole lot about, is my patent going to hold up in court? Do I have claims that are going to cover exactly what my product is? I mean, these are kind of questions that are not yet ripe for having spent a lot of time on. You really want to think first and foremost about who are all the actual people that have been involved with the technology. So you want to catalog and list out all of the actual and potential inventors and technicians that have been involved, and determine whether their contributions rise to the level of a legal invention. And again, in the U.S., there are some specifics with respect to proper naming of inventors with regard to patent applications, and the either intentional inappropriate inclusion or exclusion of an erroneous inventor can result in a patent ultimately being held unenforceable. So it's very important to get inventorship right from that perspective as well. And so once all the individuals that are relevant, that have been involved in the early stages of technology development have been identified, you want to take a look at all of their employment agreements, consulting agreements, to the extent that they were involved at a university, perhaps third-party sponsored research agreements, invention assignment records and policies. Obviously, you want to look at all the relevant license agreements and also non-disclosure agreements. And what you're really trying to do here is make sure that for any given individual who's involved with your technology, there's a clear chain of title, that individual from conception of the invention or of their inventive contribution, they've assigned or exclusively licensed or somehow otherwise granted you the rights that you need to go forward. Because later on, as the technology gets more valuable rather, and is the subject of investment or industry desire, and if these chain of title issues are not squared away, this can really make a big mess of any transaction. And also in the U.S., to the extent that the technology was developed using federal funds, so a lot of technologies generated by NIH funds given to laboratories at universities, there are pretty onerous and somewhat unknown filing requirements that universities have to make with respect to the NIH through the iEdison system. And if those filings and updates have not been properly done, that can also deleteriously impact the chain of title and give investors and partners some headaches. So with respect to patentability, as I mentioned, you don't really know what your product is at this stage, and you're not really sure which way you're going to be going in your patent strategy. So you want to have comprehensive patent applications which include sufficient prophetic examples and disclosure with respect to formulation, code administration, drug performance results, so that these elements can later be incorporated into claims to help you avoid potentially novelty or destroying or prior art that renders your claims otherwise obvious. And also these types of disclosures are also important with regard to circumnavigating any patent subject matter eligibility issues which are frequently coming up in U.S. prosecution. So you also want to look at what some of the other competitors are doing in your landscape from a patentability perspective. So it's very helpful to run informal patentability searches against hypothetical claims. And you generally just want to start to become very aware of what your competitors are doing by monitoring their patents, published patent applications, and doing searches based on their key inventors. Freedom to operate issues at this stage are going to be not really so much of a big deal. You certainly want to be aware of your landscape, your competitive landscape, and other IP out there. But if you are a company at this stage and looking for venture financing or looking to do deals, it's highly unlikely that the partner is going to require of you that you've done extensive FTO searches and have a full panel of freedom to operate opinions. But they will assume that you've done searches and that you're aware of what your competitors are doing. Additionally, in the United States, there is a safe harbor to patent infringement.